Illinois real estate exam brokerage relationships. Question 1. A consumer asks why a state real estate recovery fund might exist. Which purpose is closest during Taylor's Joliet 2-flat building file review? Option A. Providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Option B. Guaranteeing every buyer a profit on resale. Option C. Paying all ordinary home repairs after closing. Option D. Replacing the need for broker licensing. The correct answer is option A. Providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Recovery funds are designed as limited consumer protection remedies for qualifying misconduct related losses. They do not guarantee investment profit, pay routine repairs, or replace licensing and discipline systems. Question 2. A buyer reviews debits, credits, lender charges, preparations, and cash needed to close. Which document function is being tested during Riley's Aurora condominium unit file review? Option A. A zoning map amendment. Option B. Settlement or closing statement accounting. Option C. A subdivision plat approval. Option D. A deed covenant creating a life estate. The correct answer is option B. Settlement or closing statement accounting. Closing statements organize transaction charges, credits, preparations, and cash to close. Zoning approvals, plats, and deed covenants do not perform the same accounting function. Question 3. A borrower pays 2 discount points on a $125,000 loan. How much do the points cost? Option A. $1,250. Option B. $3,500. Option C. $2,500. Option D. A different result not supported by the facts. 3. The correct answer is option C. $2,500. 1 discount point equals 1% of the loan amount, so 2 points cost 2% of $125,000, or $2,500. The other figures use too few points, only 1 point, or add an unsupported amount. Stressed about your Illinois real estate exam? We can take Illinois real estate exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. Casey has completed high school and wants a first Illinois broker license after finishing coursework in Peoria. Which education path most directly satisfies the standard broker pre-license requirement during Cameron's Oak Park small apartment building file review? Option A. Only a 15-hour leasing agent course. Option B. 45 hours of managing broker education without broker coursework. Option C. A continuing education course completed after licensure. Option D. 60 hours of broker pre-license topics plus 15 hours of interactive applied real estate principles. The correct answer is option D. 60 hours of broker pre-license topics plus 15 hours of interactive applied real estate principles. Illinois broker candidates in the standard path complete 75 class hours made up of 60 hours of broker topics and 15 hours of interactive applied principles. A leasing course is for residential leasing agents, managing broker education is a different license path, and continuing education applies after licensure rather than before the broker exam. Question 5. A consumer asks why a state real estate recovery fund might exist. Which purpose is closest during Drew's Decatur mixed-use storefront file review? Option A. Providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Option B. Guaranteeing every buyer a profit on resale. Option C. Paying all ordinary home repairs after closing. Option D. Replacing the need for broker licensing. The correct answer is option A. Providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Recovery funds are designed as limited consumer protection remedies for qualifying misconduct related losses. They do not guarantee investment profit, pay routine repairs, or replace licensing and discipline systems. Question 6. Annual property taxes are $3,240, and the seller owes the buyer a credit for 57 days using a 365-day year. Approximately how large is the credit during Hayden's Elgin vacant lot file review? Option A, $270. Option B, $506. Option C, $9. Option D, $1,012. The correct answer is option B, $506. Daily proration divides $3,240 by 365 and multiplies by 57 days, giving about $506. The other choices use 1 month, 1 day only, or double the required prorated period. Question 7. Cameron failed one portion of the Illinois broker licensing exam several times during the eligibility period. After the fourth unsuccessful attempt, what must happen before testing again during Parker's normal rental duplex file review? Option A. The candidate may immediately test an unlimited number of times. Option B. Only the national portion must be retaken without additional education. Option C. The candidate must retake the required broker pre-license education before retesting. Option D. The candidate automatically receives a leasing agent license. The correct answer is option C. The candidate must retake the required broker pre-license education before retesting. Illinois exam rules allow broker candidates up to 4 attempts during the eligibility period. After a fourth failed attempt, the candidate must complete the required pre-license education again before retaking the examination. Unlimited attempts, partial automatic exemptions, and automatic licensure are not supported. Question 8. A buyer pays for the right, but not the obligation, to purchase a property at a set price during a stated period. Which agreement is described during Reese's Carbondale Lakefront Cottage file review? Option A, open listing only. Option B, tax deed. Option C, subordination agreement. Option D, option agreement. The correct answer is option D, option agreement. An option gives the holder the right to buy under stated terms without requiring the holder to exercise it. An open listing is a brokerage agreement, a tax deed relates to tax enforcement, and subordination changes lien priority.
Are you looking for AccuPlacer exam actual questions? Visit our website pokerexams.com to access AccuPlacer exam study guide with actual questions and answers. Scan the QR code or click the link in the description to get AccuPlacer exam answer key today.
Question 9. A listing closes at $390,000 with a brokerage fee of 4.5%. What total commission is generated before any split? Option A, $17,550. Option B, $8,775. Option C, $21,450. Option D, $3,900. The correct answer is option A, $17,550. Commission is calculated by multiplying the sale price by the commission rate. $390,000 times 4.5% equals $17,550. The distractors divide the commission, use the wrong percentage, or calculate only 1% of the price. Question 10. Alex negotiates the sale of another person's townhome for a promised fee. Under Illinois licensing principles, why would this activity generally require a real estate license? Option A. It is allowed without a license if the property is residential. Option B. It involves brokerage activity for compensation on behalf of another person. Option C. It is exempt whenever the fee is paid after closing. Option D. It requires only a notary commission instead of a real estate license. The correct answer is option B. It involves brokerage activity for compensation on behalf of another person. Negotiating real estate transactions for another person for compensation is a core licensed brokerage activity. Residential status, delayed payment, or holding an unrelated notary commission does not remove the need for the proper real estate license. Question 11. An ad states only a very low monthly payment without giving required credit terms or context. Which lending minus advertising law is often implicated during Quinn's Quincy Farm Parcel File Review? Option A, Rule Against Perpetuities. Option B, Fair Credit Reporting Act only. Option C, Truth in Lending Act and Regulation Z. Option D, Illinois Plat Act only. The correct answer is option C, Truth in Lending Act and Regulation Z. Regulation Z under the Truth in Lending Act governs many consumer credit advertising disclosures. The rule against perpetuities and plat laws do not govern loan advertising, and the FCRA focuses on consumer reports rather than payment minus ed trigger terms. Question 12. A seller receives $268,000 at closing, pays off a $82,000 mortgage, and pays $8,150 in seller closing costs. What are the approximate net proceeds during Sydney's Waukegan single-family home file review? Option A, $186,000. Option B, $259,850. Option C, $90,150. Option D, $177,850. The correct answer is option D, $177,850. Seller net proceeds subtract the loan payoff and seller costs from the sale price, $268,000 minus $82,000 minus $8,150 equals $177,850. The other answers omit one deduction or add deductions instead of subtracting them from the sale price. Question 13. Harper wants to pay a sponsored Illinois licensee, Kendall, directly for help with a purchase. How should compensation normally be handled during Logan's Belleville 2-flat building file review? Option A. The sponsored licensee should receive compensation through the sponsoring broker. Option B. The buyer may pay the licensee directly at any time. Option C. The title company must split the fee directly with the licensee. Option D. The licensee may accept a secret bonus if the transaction closes. The correct answer is option A. The sponsored licensee should receive compensation through the sponsoring broker. A sponsored licensee is normally compensated through the sponsoring broker rather than directly by the public. Direct payment, title minus company fee splitting outside the broker relationship, and secret bonuses create licensing, disclosure, and compensation problems. Question 14. A seller receives an offer of $250,000 and responds with $253,000 plus a changed closing date. How should the seller's response be classified during Kendall's Chicago condominium unit file review? Option A. A full acceptance of the buyer's original offer. Option B. A counteroffer that rejects the original offer and proposes new terms. Option C. A deed transferring title immediately. Option D. A lease option created by operation of law. The correct answer is option B. A counteroffer that rejects the original offer and proposes new terms. Changing material terms such as price or closing date creates a counteroffer rather than an acceptance. It does not transfer title, and it does not create a lease option unless the parties separately agree to those terms. Question 15. A small rental property has annual net operating income of $20,000 and an indicated capitalization rate of 5%. What value is suggested by the income approach during Harper's Springfield townhome file review? Option A, $100,000. Option B, $4,000. Option C, $400,000. Option D, $200,000. The correct answer is option C, $400,000. The income approach using direct capitalization divides NOI by the capitalization rate. $20,000 divided by 5% equals about $400,000. The other answers multiply by the rate, treat the percent as a whole number, or cut the indicated value in half. Question 16. During a first substantial discussion, Taylor asks Morgan whether the brokerage represents the buyer, the seller, or both. Why should the relationship be clarified early during Jamie's Peoria small apartment building file review? Option A. The relationship is irrelevant until after closing. Option B. A broker owes no duties until a deed is recorded. Option C. Agency disclosure is needed only for commercial leases. Option D. Agency and brokerage relationships affect duties, confidentiality, and the consumer's expectations. The correct answer is option D. Agency and brokerage relationships affect duties, confidentiality, and the consumer's expectations. Brokerage relationships determine duties such as disclosure, confidentiality, obedience to lawful instructions, and care. Waiting until closing, tying duties only to deed recording, or limiting disclosure concepts to commercial leases would leave the consumer without important relationship information. Question 17. Several liens are discovered before closing, including a recorded mortgage, unpaid property taxes, and a later judgment lien. Why is lien priority important during Rowan's Naperville mixed-use storefront file review? Option A. Priority determines the order in which claims may be paid from the property's value. Option B. Priority decides who may advertise the property. Option C. Priority cancels the need for title insurance. Option D. Priority makes every lien disappear at listing. The correct answer is option A. Priority determines the order in which claims may be paid from the property's value. Lien priority affects the order of payment when property is sold or foreclosed. It does not control advertising rights, eliminate title insurance analysis, or erase liens merely because a property is listed. Question 18. A buyer asks about a rumor says the property is haunted, but there is no physical defect or legal restriction affecting the property. Why may this be treated differently from a material defect during Jordan's Rockford vacant lot file review? Option A. Every rumor must be included in the deed. Option B. Stigmatizing facts usually do not have the same disclosure treatment as physical or legal defects. Option C. The broker must create a structural inspection report. Option D. The seller must lower the price by statute. The correct answer is option B. Stigmatizing facts usually do not have the same disclosure treatment as physical or legal defects. Stigmatized property issues generally differ from material physical defects or title/legal problems. Rumors do not belong in a deed, brokers do not create structural inspection reports, and statutes do not automatically set a required price reduction for a stigma. Stressed about your CNA exam? We can take CNA exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A landlord refuses to consider an applicant because of religion. What fair housing concept is most directly involved during Casey's Bloomington rental duplex file review? Option A. A lawful appraisal adjustment. Option B. A title-priority decision. Option C. Discrimination based on a protected class in housing transactions. Option D. A contract contingency automatically required by lenders. The correct answer is option C. Discrimination based on a protected class in housing transactions. Fair housing laws prohibit discrimination in housing based on protected classes. The situation is not an appraisal adjustment, title priority issue, or lender-required contract contingency. Question 20. A buyer is reviewing required environmental paperwork involving LEED-based paint information for pre-1978 housing. Why are these disclosures commonly tested during Morgan's Champaign Lakefront Cottage file review? Option A. They guarantee the property has no environmental condition. Option B. They replace the purchase contract entirely. Option C. They require the broker to perform engineering tests in every sale. Option D. They help buyers evaluate known or potential environmental risks before becoming bound to the transaction. The correct answer is option D. They help buyers evaluate known or potential environmental risks before becoming bound to the transaction. Environmental disclosure laws are designed to inform buyers about known or potential risks before or during the contracting process. They do not guarantee a problem-free property, replace the contract, or require brokers to perform technical engineering tests in every transaction. Question 21. Two firms agree that one will serve buyers only in Normal while the other will avoid that area and focus on Carbondale. Which antitrust concept best fits during Taylor's Joliet Suburban Ranch home file review? Option A. A market allocation. Option B. Valid escalation clause. Option C. A leasehold estate. Option D. Statutory redemption period. The correct answer is option A. Market allocation. Competitors who divide territories or customers can create an unlawful market allocation scheme. Escalation clauses are contract tools, leasehold estates are possessory interests, and redemption periods relate to foreclosure law. Question 22. Quinn and Sydney both claim the same earnest money after a failed Illinois purchase contract. How should the broker view disbursement during Riley's Aurora commercial suite file review? Option A. The broker may give the money to the latter party. Option B. The broker should follow the contract, written instructions, or lawful dispute minus resolution process before releasing funds. Option C. The broker must always keep the money as commission. Option D. The buyer automatically receives the money regardless of contract terms. The correct answer is option B. The broker should follow the contract, written instructions, or lawful dispute minus resolution process before releasing funds. Earnest money disputes require careful handling under the contract and applicable escrow rules. A broker cannot choose based on pressure, convert the money into commission without entitlement, or ignore the party's contract rights. Question 23. Drew prepares a price opinion for a seller in Quincy to help set a listing price. Which limitation should be remembered during Avery's Evanston farm parcel file review? Option A. A CMA always creates a guaranteed sale price. Option B. A broker price opinion transfers title. Option C. A CMA or broker price opinion is not the same as a formal appraisal by a licensed appraiser. Option D. A CMA eliminates all disclosure duties. The correct answer is option C. A CMA or broker price opinion is not the same as a formal appraisal by a licensed appraiser. A CMA or BPO can help estimate market price for brokerage purposes, but it is not a formal appraisal. It does not guarantee a sale price, transfer title, or remove disclosure obligations. Question 24. An unlicensed assistant named Alex is asked to explain offer terms to a buyer at an open house. Why is that risky during Cameron's Oak Park single-family home file review? Option A. Unlicensed assistants may perform every brokerage task if unpaid. Option B. Only title companies need real estate licenses. Option C. Licensed supervision converts negotiation into clerical work. Option D. Explaining or negotiating transaction terms can cross into licensed activity. The correct answer is option D. Explaining or negotiating transaction terms can cross into licensed activity. Unlicensed assistants may perform clerical or administrative tasks, but explaining terms, negotiating, or advising consumers may require a license. Being unpaid, supervised, or involved with a title company does not transform licensed brokerage functions into purely clerical work. Question 25. A landlord uses a consumer credit report to evaluate Drew's rental application. Which law commonly appears in property management screening questions during Drew's Decatur 2 flat building file review? Option A. Fair Credit Reporting Act. Option B. Truth in Zoning Act. Option C. Statute of Frauds Only. Option D. Uniform Commercial Code Bulk Sales Rules. The correct answer is option A. Fair Credit Reporting Act. Tenant screening that uses consumer credit information implicates the Fair Credit Reporting Act. The other choices do not specifically govern consumer reports used to evaluate rental applicants.